Thank you, and good evening and welcome to the virtual meeting of the Licence and Regulatory Committee. It is 6 p.m. on Thursday the 10th of September 2020. My name is Councillor Linda Broadley and I am Chair of this committee. My fellow Councillor, Councillor Latif Dar, is the Vice Chair. In accordance with the regulations made under Section 78 of the Coronavirus Act 2020, this remote meeting is being live streamed and recorded. The audio-visual recording will be made available on the Council's website and YouTube channel shortly after the meeting. All participants in this meeting are reminded to speak slowly and clearly in the direction of their device's microphone at all times. A reminder that mobile phones and other electronic devices should be turned off or put onto silent mode, and that those participating in this meeting should refrain from taking telephone calls. For the purpose of recording of attendance, I can confirm that the following councillors are present and participating in this remote meeting. Councillor Rosemary Adams, Councillor Bill Bolter, myself, Councillor Linda Broadley, Councillor David Carter, Councillor Michael Charlesworth, Councillor Latif Dar, Councillor Robert Eaton, Councillor Linda Eaton, Councillor Kamal Gattara, Councillor Geoffrey Kaufman, Councillor Lily Kaufman, Councillor Claire Krosky, and Councillor Helen Lloydell. We also have the following officers in attendance. Samuel Ball, trainee solicitor, who is acting as the Democratic Services Officer. Tony Thorne, Regulatory Service Manager. Dave Gill, the Head of Law and Democracy and the Monitoring Officer, and Judith Sweeney, the Democratic and Electoral Services Officer. For the purpose of the regulations, I can confirm that before this remote meeting went ahead, all participants confirmed that they can see and or hear all other participants. This meeting will be conducted in accordance with the Council's adopted remote meeting procedure rules and the summary of which is attached to tonight's agenda for reference. May I also politely remind all participants that they must not act in a disorderly or disruptive manner or otherwise interfere with the Council's proper conduct of its business. Thank you. Apologies for absence.
Thank you, Chair. Apologies from Councillors Frank Broadley and Dean Gamble.
Thank you. Appointment of substitutes?
No substitutes, Chair.
Thank you. Declarations of interest? No hands raised. Minutes of the previous meeting. These are for noting. May I sign? Yeah. Action list on page 10 of the agenda.
Thank you, Chair. Would you like me to take members through that action list?
Yes, please.
Thank you then, Chair. Starting with item number 1, the review of the carriage and private hire licensing policy in March. The comments of members were noted and incorporated into the draft policy where appropriate. The consultation on that, however, was delayed because of COVID-19. So that is something that we're going to be picking up again shortly. With regard to item 2, you'll see there's a comment further below, and that's in respect of the Disability Discrimination Act. There was clarification required in respect of whether wheelchair accessible standards as may set out in the DDA apply to hackney carriages and private hire licensed vehicles. As I've explained in that note there, Chair, the DDA was repealed in England, Scotland and Wales on the 5th of April 2011, and it was replaced by the Equality Act 2010. Under section 160 of the Act, the Secretary of State has the power to make regulations to be called the Taxi Accessibility Regulations, designed to ensure disabled persons access to taxis. However, those are not yet in force. So at this stage, we're not in a position to take any further action on that matter. Obviously, as soon as the Secretary of State lays the statutory instrument, then that will be fed into our policy.
Thank you. Before you move on, we have Councillor Geoffrey Kaufman with a question.
Thank you, Chair.
Mr. Kaufman?
Yes. Thank you very much for the explanation, which I do understand. My question relating to the hackney carriages, how is it that if there is no legislation to enable us to carry this out, how is it that other local authorities make a standard for their hackney carriages and they all include, those that make the standard all include disability access? If I was to go into Leicester, if I was to go into Nottingham, a lot of other places, they have a standard taxi. In fact, Nottingham used to be dark green. I don't know what colour it is now. So they specify what hackney carriage, and I specifically say hackney carriage. How's it they manage to do it? What legislation can they do it under?
That's in their policy, and what they've deemed is that hackney carriages have to be the London type hackney carriages, and the London type hackney carriages are capable of taking disabled persons. Our policy specifies a saloon vehicle with at least 4 doors that can carry 4 passengers. The issue around the London cabs is that they're in the region of £70,000 new. And if we were to determine, for instance, that going forward in our new policy that all vehicles were to be London style cabs, that would create an immense burden on the trade, and I suspect that we're likely to be challenged in court on that basis. The issue is whether or not there's any demand, and we do have a number of vehicles which we've licensed which are capable of being used by disabled people, but there's been no pressure either from the public or from the trade that we should move vehicles, or most of our vehicles, to disability friendly vehicles. Nationally, the Institute of Licensing are pushing the government to lay the regulations, but as you appreciate at the present time, there's other things on their mind.
Yeah, I accept that, but I wish I would have known when we were discussing it that we could, as an alternative way of achieving that, at least consulted on using a London style, for lack of a better way of describing it. I wish when we were actually going through the consultation process, we could have offered that and seen what the public said about it. But I don't think it was ever offered in the consultation, was it?
Well, as it stands, Councillor Kaufman, the consultation hasn't been completed. It hasn't even started. If you're suggesting that that's what you would like, we could include a question in the consultation. And if the chair's happy to do it on the basis of affirmation from members tonight, when we go out to consultation, we can include that question for you.
Well, I'd be grateful if you could. At least we can get an answer. And if we get criticised one way or the other, we can at least quote the consultation. So I would like to move that that question added. But I'll leave it to you to do the appropriate wording. But
thank you. But I mean, that's a matter of you, Chair. You're happy to accept that and have a question?
Well, I'm happy to accept it, providing it has a seconder. Do we have a seconder? Councillor Michael Charlesworth?
Yes, Chair, I'll second that.
Okay. So we have the motion on the table from Councillor Kaufman that this is included in the consultation. Can people raise their hands if they're in favour, please?
Is that raise your hand on the screen, or raise your hand?
Raise your hand on with using the remote. Raise your hand so that the officers can count.
Can you raise your hand, Chair, then, please? Thank you. For the sake of looking at that, Chair, it looks to me that is unanimous. If Mr. Ball agrees.
Yeah, that's a majority of, unanimous, including those who are raising their hands physically on the screen.
Thank
Okay,
you. So we'll include that in the consultation then, Chair.
okay, thank you.
Thank you.
Anything
Moving on-
else, Councillor Kaufman?
No, that's all on that bit. Thank you very
Okay,
much.
if you'd like to continue then, Mr Gill.
Thank you, Chair. The next item is a full breakdown of the following applications to provide on a quarterly basis. Given the fact that we have had the COVID pandemic and we have been restricting the amount of work that has been undertaken by the licensing team, we've not been accepting new applications, for instance, and there's been very few house-to-house collections and requests, etc. That will be reported at the next committee, which is scheduled for the 26th of November. In terms of the appropriate liaison, you'll see point 5, you'll see my note there with regard to the view that we didn't think that it would serve any useful purpose as the two regimes are entirely separate. Having said that, as a result of the pandemic, we have engaged with the police. We have a nighttime economy meeting that's held remotely on a weekly basis. That involves officers from licensing, environmental health and the police. Not only does it extend to nighttime economy, but it also extends to any other issues that might arise. So this action list is now somewhat out of date with that response. My view is, in fact, the police have requested that these meetings continue for the foreseeable. In fact, a comment was made by the sergeant yesterday that the bosses, in inverted commas, at police headquarters were very impressed with the proactive way that Oadby and Wigston had dealt with the nighttime economy and the other issues, and they've requested that we continue with these meetings. So the plan is that they will continue weekly for the time being. We have a number of issues coming up. We've got Diwali, we've got Halloween, we've got bonfire night, and then obviously through into Christmas and New Year. So we will be maintaining that regular contact with the police going forward. Item number 6, with regard to premises offering massage and other special treatments. It was our intention originally to try and introduce bylaws to cover those matters, but we've been advised by a barrister that the legislation doesn't permit the making of bylaws in respect of those sort of services. Having said that, the Institute of Licensing at a national level is pushing for the introduction of legislation that would deal specifically with these issues. So we will be feeding into that consultation and supporting such a move. Item 7, in respect to the dogs, the dog warden service ended on the 23rd of March as a result of COVID, and it has only recently been reintroduced with the patrols. So again, we don't have sufficient information that we can provide in respect of the dogs. We will report that back at the next meeting. With regard to the food safety, in the same point, you'll see from the report there that, again, inspections came to a halt. Officers were engaging with food businesses and businesses. We said that there are quite a few new ones where people were delivering meals in the borough, cooking at home and delivering meals, and also a lot of the public houses who were closed to customers on the premises were doing takeaway foods. So the officers have been engaging fully with them, providing them with all the appropriate advice and guidance remotely. The FSA have indicated that we now need to start doing the physical inspections, and the first inspection was actually conducted earlier this week. We have a programme in place to go forward and make sure that all of the premises that require an inspection will receive an inspection.
Sorry, while you're on that, can I ask just a question? There's been a lot of people on social media that are cooking and offering food for sale. And a lot of the comments that people are making is about them having a food license and insurance and asking to see it, and then they're blocked and whatever. Is the council aware of that? And if people report somebody who is, say, living in our borough that is doing it, would it then come under the council's responsibility to check?
Yes, we officers themselves have been proactive. A number of the officers actually live in the borough and subscribe to social media feeds such as Spotted Wixton and Spotted in Wixton and the rest of them. And where they identify people, they do make contact with them and advise them. In fact, we did actually receive a complaint into the office because a person who was having regular meals supplied was most upset when the person supplying them stopped doing it because the council had made contact. But most of the time we've been able to provide them with advice and guidance and ensuring that they are complying with the necessary food standards and that they're registered as a food business if required. So we have taken a very proactive approach on that because it became apparent very early on that lots of people were doing it.
Right. We have a question now from Councillor Michael Charlesworth.
Thank you, Chair. Yeah, I suppose it's on that point. I mean, I have an interest here. I run a food business. I registered that food business, and like Mr. Gill said, a lot of people have been setting up recently and doing different things. Do they have to register? Is the first question. Second question is, I know we're in different times now, but when I set up, an inspection had to take place within 3 months of a business opening up. Have we let that lax because of COVID, nationally or locally? And the third one was public liability insurance. That's the one insurance that I was told you have to have, and I have it. Is that a requirement of anybody who sets up a food business to the public?
Public liability insurance is actually a risk. It's a risk-based thing for a business. So in reality, whilst people are advised that they should have public liability insurance, there's no requirement. What it does, it protects the business owner in the event that something happens. So an example might be that if we have a shop on Bell Street and somebody occupies the shop for whatever purpose, we wouldn't go down there and say to them, you must have public liability insurance. It's for the business to manage the risk. What we have been doing, we have been contacting people with regard to inspections. I know that a number have been completed via social media. So we've had, WhatsApp videos of the kitchens and the things, and we've been providing as much advice and guidance as possible. And I say physical inspections have not been possible because the FSA ruled that we shouldn't be doing them, and B, there was obviously the huge risk to the staff. But those now are up and running, and I'm going to say we've got about 70 businesses that we have to do inspections of over the next month, 6 weeks, and there is a program to do those, and we've dedicated officers to doing that work.
Thank you. Do you want to come back, Mr. Charlesworth?
No, thank you, Chair.
Okay, Councillor Bill Bolter.
Thank you, Chair. Just an item for your action list for next time. I understand the county is now passing responsibility for...
Okay. Mr. Bolter, that is already on the verbal update at the end of this agenda.
Right, okay.
Thank you. If you'd like to continue, Mr. Gill.
Thank you, Chair. So moving on to number 8, assurances were requested in respect of College Garth and when they euthanize a dog. As stated there, financial considerations alone would not be a factor in any decision that is taken by College Garth. And then more detail requested on the dog warden patrols. As I've said, those dog warden patrols halted March 23rd, along with virtually everything else. They have just recommenced, and again, we will report back in November with more detail. There was an issue on the last report about a dog being seized in the borough being returned to an owner. The dog was found within the borough. The owner lived in the neighbouring district, so it was a matter of just returning it. It wasn't a matter of the officers going into the neighbouring district and seizing the animal as it was straying. So that's the end of the action list as it stands, Chair.
Right. I did ask earlier this week for a verbal update on pavement licensing, given that the county council has moved their responsibility onto the local council. Could you give us that verbal update?
Yes, Chair. And just for the point of clarification from the outset, the function is not the function of the county. The function of granting a pavement licence is a function of the licensing authority, and the licensing authority are the districts and the boroughs. What has happened is that as part of the COVID-19 response, there's been various working groups across the whole swathe of services. And when this was proposed by government, the Local Resilience Forum gave the task of making it work to the Market Towns Group, which is a specific cell on the Strategic Command Group. What has happened is that group has agreed a common process with common forms on how the applications will be managed, and they will come into the districts and boroughs. We have to consult with county with regard to the siting of a pavement cafe, because they're the highways authority, but it is a consultation. It is not their decision, so therefore we do not have to agree with them if we think it's appropriate for the license to be granted. So the 2 or 3 people have said about county passing the responsibility down, but it was never county's responsibility. It was always the districts and boroughs. They have just facilitated the process by which we can have a streamlined application. The consultation period is 5 days, and that's not working. That's 5 days, so including Saturdays and Sundays. So we've had to have a mechanism in place to make it work. In terms of fees, the fees are set by government in the sense that we can charge up to a maximum of £100 for an application, and a decision has been taken internally that we will charge £100. Some authorities are doing it for nothing. Some authorities are charging 50 quid. There is a lot of work involved for officers, and obviously it will take them away from their normal work. So the view has been taken that if the statutory maximum is £100, then we will apply the statutory maximum.
Thank you. Councillor Bolter.
Thank you, Chair. Yes, that's an interesting explanation. This was introduced by county about 4 years ago as a money raising exercise. They charged a lot more than £100. It depended on how much payment they were taking up, and they raised quite a lot of money by doing this. So will the boroughs keep the money? Will the money go to county?
The £100 fee goes to the boroughs.
Right.
It's a simple. The position is that the pavement licence is an add-on to the Licensing Act 2003, which is the responsibility of the districts and the boroughs. We're the licensing authorities. We have to consult with the county, we have to consult with the bus services and the police and everything else, but ultimately that decision rests with us. And I appreciate what you're saying, Councillor Bolter, but the previous licenses or pavement licenses are done under the Highways Act 1980, which in the main is county's responsibility. This is our responsibility.
Do you want to come back, Mr. Bolter?
No, just interesting that county's passing it to us at I considered less money than what they were making out of it. That was all.
Well, it's not the county passing it to us, Councillor Bolter. It's the government. The government have made the statutory instrument. they have decided it's licensing authorities because it's connected to the premises. The idea is that where you have a public house that has limited internal space that wants to maximise their income, it will enable them to utilise land adjacent to their premises. Doesn't have to be a highway in the strictest sense. The public houses can utilise their car parks. It might be a piece of open space, public open space, a green next to it, and if they get consent from us, they can do that. This only relates to the highway, and in some cities, what they're doing is they're closing off the parking bays in an evening and allowing tables and chairs to be put in the parking bays, provided they're adjacent or opposite the premises that holds the premises license.
Okay. Thank you for that. We move on to petitions and deputations.
None received, Chair.
Thank you. Move on to item 7, statutory guidance on taxi and private hire vehicle standards. Can I just say that questions can be asked on this, but the report is for noting only. Is it Mr.
I'm going
Gill?
to deal on that one, Chair, if that's okay.
Thank you.
This is the first statutory guidance that has been issued by government in respect of taxis and private hire. Previously, there was best practice, which was guidance that local authorities could take into account if they wish to. This guidance stems from the issues that have arisen around the involvement of taxi drivers in the child sexual exploitation cases across the country, and government have decided that it would be appropriate that all licensing authorities apply the same standards when they license the drivers. There are some changes, and what I've done is highlighted the changes as best I can, and there's also the quick reference guide at the back, which is a diagram of the changes. Just briefly going through it, Chair, the first change is the fit and proper test. Not every authority uses the fit and proper test, and in fact there never has been a statutory fit and proper test. If you look at what's in paragraph 2.1, I'm sure you'll all recall it from having sat on committee.
Mr. Gill, can I just stop you for 2 seconds and just confirm if the chair is still connected?
I am still connected. It's just come up low battery, so I've just plugged it in.
Okay. There we go.
There
Sorry,
we are,
Mr. Gill.
Thank you very much, Mr. Ball. So in 2.1, we have the test, and it's based very simply on the test that we've all used before, which is, would you allow your son, daughter, or somebody that you care for into a taxi with this person? That's the first time that there's been the statutory definition across the country, which everybody has to apply. They've also made some changes in respect of information sharing, and in 3.1 I make reference to NR3. The National Anti-Fraud Network is a network which of local authorities. There's a lead authority which provides us with information on scams and all sorts of other things, and they have a register which is a voluntary scheme where if we refuse a driver or revoke a driver, we can then report it to them, and then if we get an application in from somebody, we can go and check the database to find out whether they've been refused elsewhere. Because as you appreciate, our forms do say, have you ever held a license anywhere before? But it's reliant upon the driver being, or the applicant being, truthful as to whether or not they've held a license somewhere else. That now is making it clear that NR3 is no longer voluntary. Every time we refuse a driver or revoke a driver, we must tell NR3 so that people can check against the database. Moving on to 4, we as a council have done CSE training for a considerable amount of time, but not all authorities do it. What the government is looking for now is that the child sexual exploitation, the CSE, should be expanded. So it will not only include CSE, but it's also going to be including safeguarding, and that's adult safeguarding and also child safeguarding. And one of the things that will be included in there will be county lines, the danger that young people are being transported around the country in taxis for the drug trade. So there's a piece of work that we need to do in order to update our CSE training, which we're going to do shortly. Certificate of good character. It's always been a difficult one where you get an applicant who is an EU national or a national of another country. That we ask for a DBS check for our drivers, and if you are in the UK and have lived in the UK for a while, or were born here, we can get a certificate from the DBS service to find out whether you've got any previous convictions. What they've now said is that we should be able to get a certificate of good character. So where we have somebody who is who's moved to the country from abroad, who's got a right to work, but not got a history of living in the country, we can actually make a request to the country from which they've come from to get a certificate of good character, which is effectively a DBS check by another name. What the quality will be, we don't know, but it is something that we've not been able to do before. Enforcement, which is an interesting. The current position is that the only people that can enforce against a taxi are the people that license the taxi. And we know that if we license a hackney carriage in Oadby and Wigston, it can be used anywhere else in the country as a private hire vehicle. And I know that we've got at least one driver who's registered with us as a hackney and works in Kent as a private hire. Now, the Kent authorities can't enforce against him. All they can do is refer that back to us. So obviously there is an issue there. And what it's talking about is it talks about having an agreement. So co-authorising officers. I'm sure some of you are aware that we've had problems in the past with taxis up at the university, with the city taxis working in Oadby round the halls of residence, and the only way we can catch them is our officers. Going forward, what we can do is enter into an agreement with Leicester City, who've got more officers than us, do joint operations and go there. I think one of the best examples would be East Midlands Airport. Every year, the licensing team at North West Leicester, who are responsible for East Midlands Airport, run an operation 2 or 3 times a year, and they invite officers from all over the East Midlands. And the reason they do that is because if it's one of our taxis, it's only us that can enforce against it. Under this new arrangement, we could sign an agreement with North West, which means that if they just happen to be there doing whatever and they find one of our taxis that's committing an offence, they can deal with it. The prosecution of it would still remain with us, and what would happen is the paper would be referred back to the legal team at Oadby to deal with. But at the moment, all they can do is put in a statement to us. We then have to conduct an investigation to verify what's being said. This will make it much easier and much quicker to enforce against them. Number 7, mandatory language proficiency tests. It's often been a complaint that the ability of some of our drivers to speak English is to a conversational level is not good. There has been difficulty in trying to introduce a language test at local level because it always runs the risk of a challenge. Now with this guidance, we are being told that we must. How that will be introduced, we're not quite certain. I think if we could identify something, a course in basic English with a qualification that's run by a a college or something like that, then that may well be the route that we go down, where we say that people must attend a structured course and pass it, and then we can deal with it in that way. But again, a lot of these things, it only came out in July. We're still working round how we're going to make it effective. Previous convictions. So for the first time, you recall it 2 years ago, it was 2 years, we adopted the Institute of Licensing's guidance on the relevance of previous convictions, and that was incorporated into our policy. This now is mandatory, so every licensing authority has to include the guidance, and there's an annex to the guidance which sets out how you deal with previous convictions, and every authority has to include that in their policy. So that should mean that we would have a standard approach to previous convictions across the country. So whereas we might say no to somebody at the moment, another authority might say yes. But when this is incorporated in their policy, we should be saying no, they should be saying no. So that is a great help, because we do know that taxi drivers have a habit of shopping around, going to different authorities that have lax standards compared to us. And I think that's about it. Just going through. One other thing, very briefly, on this, the diagram at Appendix 1, Chair, you'll see various bits. What we've tried to do is include the highlights for you. In terms of criminal convictions and checks, the interesting one is that at the moment we have, thank you, Sam. At the moment we do checks on private hire operators, we do checks on vehicle proprietors, we do checks on drivers, but what we don't do is checks on booking and dispatch staff, and that has now become mandatory. So all of our operators that have radio men, or whatever you want to call them, they are going to have to provide us with a basic check for the DVS. And on the right hand side, as I looked at that, where the big hazard warning is, this is retrospective, which is unusual. Normally when legislation comes in, it goes forward. What they're saying is that if we have a driver or an applicant come to us today and we would refuse him on the basis of this guidance, if we also have a driver that we've actually previously licensed who falls within the categories here, then we should go back and revisit that, the grant of that license. And it's not just on renewal, because our licenses are issued for 3 years. So this guidance came out in July. So if we granted a license in June 2020 that would fall foul of this new guidance, we don't wait until June 2023 to address it. We have to address it now. So there's going to be a very large piece of work for the officers. I think we've got about 400 drivers that we're going to have to go through and apply this new guidance to each of those drivers and make decisions about whether or not we're going to allow them to continue as drivers or whether we're going to revoke the license. So that is going to be a major piece of work, and I've no doubt it will also lead to a major amount of legal work in terms of appeals and from the drivers. Some of them may have been driving for many years. I think particularly the one I'd look at that would be the language proficiency. You know, if somebody's been driving for 10 years and then we're suddenly saying to them, I'm very sorry, but you don't meet the standard for the language proficiency, I suspect that if you revoked, we'd end up with a an appeal or two. So that's a brief overview of the guidance for you, Chair. Happy to take any questions.
Right, thank you for that. I welcome this, and I welcome the fact that it's retrospective. So that is a good thing for me. Councillor Lily Kaufman, we have a number of questions. So Councillor Lily Kaufman first, please.
Thank you, Linda. I note the report, but I cannot see anywhere any directions on where we are at the minute on COVID-19. I don't even know what the rules and regulations are for taxi drivers. Are they supposed to be wearing masks? Are they asking their passengers to wear masks? I would have thought it would have been pretty important to put something in, especially under number 6, enforcement, the guidelines and the regulations on COVID-19. Thank you.
If I can answer that, yeah. That there is specific government guidance in respect of transport and COVID-19, which is completely separate from this. This is intended to be a long-term process for the licensing of taxis. The guidance for COVID-19 sits separate because we don't know how long that's going to last. It may be over by the end of the year, it may be another year, 2, whatever. But the two are completely separate. But just for members' information, we've had a number of requests from taxi drivers about having plastic screens between the driver and the passenger. And what we've said is that we're not going to mandate them. We're not going to object to them, but they need to make sure that there's no health and safety risk posed by having a screen fitted in the vehicle. And obviously we're out all the time watching and monitoring. I've seen taxi drivers wearing masks. I've seen taxi drivers not wearing masks, but it's guidance, it's not mandatory.
Do you want to come back, Mrs. Kaufman?
Yeah, very briefly, obviously it's very lax of the government because we are worried about car share and that type of thing. So this is obviously something that the government has really missed out on. But thank you for clarifying that it is a separate thing. Thank you.
Thank you. Councillor David Carter.
Thank you, Chair. Like you, I welcome this document, and it seems to me that it's encouraging consistent standards across the country. It's encouraging cooperative working, and to pick up Mr. Gill's comment, it's encouraging those lax authorities to raise their standards to the high standards that he and his team are seeking to achieve in Oby and Wigston. But I have a question about 2.2. It's just really a question of clarification. It's the question. It's the statement under the new guidance. All drivers and operators will be required to subscribe to the DBS update service. Does this mean that they will have a responsibility for reporting and notifying information that to DBS, or do we continue, or is the situation still that the responsibility is for statutory authorities to report information that affects their standing with DBS? I wasn't quite clear what the implications are of them having to subscribe to an update service.
Right. The position is that we do an enhanced DBS check on every driver and on every applicant, and it's done once every 3 years. There is a duty on the driver to report to the council any infringement whatsoever, whether it be a fixed penalty notice for a traffic light or speeding, whether they be arrested for any offence, even if they're not charged, whether they're cautioned, and any criminal conviction. The DBS enhanced service is a system where once you are subscribed to it, there is a code that is issued which enables us as an authority to go in to the DBS and check the record of the driver. And the intention is that that would be done every 6 months. There are many occasions when we get an application for a renewal and we discover that the driver has been arrested or has done something and they've not told us. And the idea of this is so that drivers cannot hide their convictions from us. So as an authority, we are better informed as to the fitness and propriety of that person. And if we were to go into the DBS and to check and discover that somebody had been arrested for assault or battery but not yet charged, that would enable us to make a decision as to whether or not we needed to suspend that driver pending the outcome of the case, or if there's a conviction there that warranted, we could revoke it without relying on the driver to tell us about it.
Okay, Mr. Carter, do you want to come back?
I think so. So is the change then that there's now a responsibility on the driver to notify of relevant information, which wasn't previously there before?
No, there's always been a requirement on the driver to
Yep.
notify us of any relevant information, but that would be a breach of our policy by itself. The duty is on the driver to pay the fee, because there is a fee to be paid, an annual fee. It's about 14 or 15 pounds, I believe, to have this enhanced access. But that duty is on the driver to pay that fee to enable us as a licensing authority to go in and look at his record. And obviously, if they don't pay it and they're not subscribing to it, then that would be a ground for certainly an investigation as to what they're hiding, and possibly even a revocation.
So that's the change, that they've now got to pay a fee to enable us as an authority.
Well, yeah, the change is that we can now do it every 6 months, whereas previously it was every 3 years.
Right, thank you. That's clarified the point. Thank you.
Okay,
No problem.
thank you. Councillor Helen Lloydell?
Yes, thank you, Chair. Can everybody hear me?
Yes.
Yes.
Yeah. Can I just ask, before I ask my question, I've got 3 questions. Did we have a breakdown in the middle of Mr. Gill's presentation? Because at one point I couldn't hear him and he seemed to be running out of steam. I've never known Mr. Gill to run out of steam during anything. And I was a little bit concerned because I missed quite a bit. So could you just make sure that that has not happened? I want to know whether it's my iPad that's wrong or whether it was the actual presentation. So could Samuel answer that question first, please, Chair?
Yeah. For you, Chair, the connection was stable, so it seems to be a local issue with your device, Councillor Lloydell.
Okay, so it's probably my iPad not happy with Mr. Gill's presentation. Don't worry, Mr. Gill, then I'll persevere with it. I've got 3 questions, Chair. The first one is on point 2.1, the fit and proper person. I welcome this, but I would like to know, first of all, Mr. Gill, who makes that decision? Will it be the licensing officer, or will it be somebody with management? Not sorry, I'm not saying this correctly. Will it be the licensing officer, or will it be the legal department? So that's my first question.
Do you want me to answer that first, Councillor, and then if we answer that and then do the second question and the third, it makes it a little bit easier for me. So in terms of that test, as a general rule, we have a range of things that are required. Can you hear me?
Yes, I can.
Yeah.
Thank you.
So we have a general requirement. So we need people to have a driving license, and we need people to have insurance, and they need to have done the CSE test, etc. Where that test falls in generally is when there is some issue around the character of the person. So generally it is to do with previous convictions. Now the officers will apply, the licensing officers will apply the guidance or on convictions, and sometimes it might be a straightforward answer. without putting too far, if somebody's got a conviction of rape, well, that's it, isn't it? You know, they're not fit and proper to be a taxi driver, and that will be the end of it. If it's more nuanced and balanced, and it's a maybe not, then they will normally take advice from myself, and I'll give a legal view on it. And of course, if I'm not happy, then it will end up before members on a subcommittee, and the members will make that decision, having received legal advice from myself or another legal officer.
Yeah, thank you, Chair. I think that's. Do you feel, Mr. Gill, that the wording of that could be open to a number of challenges, or are you quite happy with that wording? That
wording replicates, in a shortened version, the wording that is contained in the case of McCall and Rushcliffe Borough Council, and I'm comfortable with that wording. I know it's got nuances on it, but it's always been the case that the question has been, would you want one of your relatives in this car with this person? Would you trust that person to drive your grandson or granddaughter or elderly mother? And unfortunately, I mean, the wording is the wording, and it's statutory guidance, so therefore we have to accept what the wording is.
Thank you. So long as you're happy with that, if it's challenged by anybody. My second question, Chair, is to do with 4 safeguarding and child sexual exploitation. It says there in 4.1 that this is required by all new applicants. Now, I note that the report is retrospective, but could you assure me that all existing drivers will have this extended training, and that we are keeping records that these drivers have been or have had the training and will know what to do if they see or have any causes for concern? It's not just new applicants, it's existing drivers as well. So could you answer that one, please, Mr. Gill?
Not a problem. All drivers are required to do the CSE training, and we've required all new applicants for a number of times, but we've also required existing drivers. Obviously, what we do with them is, if we can get a new driver and do the CSE course before the grant of the application, then we will do. If it's an existing driver that's already been granted, then they are required to undertake it. If the new applicant doesn't take the CSE course, then they don't get the licence. If the current driver doesn't do the CSE course, then they get suspended, and they are suspended until such time as they do it. Again, given COVID, we've had a real issue with this with regard to the ability to undertake these CSE courses, and I think it was on the members' bulletin last week. We have just started doing them again. We have about 6 or 7 programmed over the next few weeks, and if drivers don't turn up, obviously we give them opportunities to more than once, you know, perhaps 2 or 3 occasions when they have to turn up. But if they don't turn up, they'll just get suspended. And if they continue not to do it, having been suspended, then we'll just revoke them.
Thank you, Mr. Gill, and thank you to the officers, because this is extra work for them. And I do understand that it must be difficult, especially at this time. My final question, Chairman, and thank you for persevering, is for certificate of good character. Mr. Gill, how reliable, in your experience, how reliable are these certificates of good character for our taxi drivers? Thank you.
Thank you, Chair. I mean, the issue is we have to take them on face value. So quite often, and we have a lot of drivers that are from the Indian subcontinent, and they may go away on extended holidays. As it stands at the moment, we don't have any information when they come back to us because we don't have that ability. We will be able to make those requests. Those requests will be dealt with by the local police station or the local public authority. We're going to have to accept them on face value because obviously we're not going to be in a position to undertake any inquiries, in the subcontinent. It's just one part. The certificate of good character is just one part of the assessment process. So it may well be that they fail on something else. So it's unlikely that it will be the defining reason to grant a licence.
Following up from that, Chair, Mr. Gill, do you know what percentage of our drivers have this certificate of good character as opposed to ours?
Yeah, at the moment, Councillor Lloydall, none of them, because this is new. This bit is new, and previously we've not been in a position to get criminal records convictions from abroad. So it is very, very difficult. But this now, going forward, we'll be starting to do.
Thank you, Chair. Thank you.
Thank you. Councillor Latif Dar.
Thank you, yeah. Yeah, I've got two not very lengthy questions. I'll ask them both and Mr. Gill can answer if you please. First one is on the recommendation. Saying is the standard we're setting, should it not be approved by the members? It says it's for noting. If you can clarify that, please. And the second one on enforcement. Just to clarify in my head, you said if one of our drivers gets reported by Nottingham, for example, they won't take the action. Will they tell us to take the action? Is that right? Thank you.
Thank you, Councillor Dar. Firstly, with regard to your first question, the reason why the report is to be noted is because it's statutory guidance. It means that we as an authority have to have regard to it. There's nothing that we can't change it. It's as it is, we just have to apply it. But it was felt appropriate that we bring it to members so the members were informed about the changes that are going to be taking place. And with regard to the enforcement, yes, the position is quite simple. And I quite often refer to my former stamping ground, but it's an example that is useful. When I was at North West Leicestershire, we had a vehicle at the Download Festival, massive event, 70,000 people, and offences were committed. That driver was registered in Liverpool, and we could take no action against it, and we had to refer that matter to Liverpool to deal with. And likewise, they had one of our drivers up at Aintree, and again, they couldn't do anything about it. It had to be referred back to us, and it makes it really difficult because unless you get the evidence, perfect evidence, when it arrives in Wigston, it really is difficult to try and resolve it. What this will allow is it will allow people in Nottingham to deal with the matter there and then, and what all that would happen is they would ask us for authority to act on our behalf in legal proceedings. So it can all be dealt with in Nottingham, and it means the driver will be dealt with, whereas at the minute the chances are they commit an offence somewhere and they might get a conversation with the licensing enforcement officer, but that's as far as it goes. Whereas this gives the regime teeth to deal with drivers that are not behaving.
Okay, is that fine for you, Councillor Dahl?
I believe he's nodding, Chair.
Okay, thank you. Councillor Michael
Got
Charlesworth.
muted. Sorry, I unmuted myself. Yes, second, yeah.
Okay, thank you. Councillor Charlesworth.
Thank you, Chair. I'm glad Mr. Gill has run this by us today. I think it's a step forward and a big improvement on where we were. So, yeah, and I'll not just note it, I'm all in favour of it. I do notice, though, that this and other agenda items have the potential to present a lot of work for the council. And I'm just wondering if Mr. Gill is confident in his department's ability to deal with things. I know you'll plough through them as best you can, Dave, but some reassurance that we'll be able to deal with the workload would be welcome.
Thank you, Councillor Charles. We do actually have a meeting programmed in next week, and I will be meeting with my managers across environmental health and licensing, and we're looking to draw up an action plan. We appreciate that we're not going to be able to do everything all at once. It's not going to be a big bang, but we will have an action plan so that we can work towards getting this in process. The fact is that because it's statutory, we have to have regard to it anyway. So if it's not in our policy, it doesn't really matter, because the policy is read in conjunction with the guidance. But obviously what we would like to do is make sure that our policy fully reflects the guidance. So I say we will have an action plan, and it's about managing resources. If needs be, you know, I'm going to have to move people around. I'm going to have to get people. I have people from other teams within the council that have been volunteered, I think is the phrase that I would use. They might not see it as that, who are being brought into my department to do admin work that frees up the officers so that we can get on and do other things.
That's good news. Just keep us updated through the monthly bulletin.
Yeah. The bottom line is, if there is an issue, and I feel that we are not in a position to deal with everything that we've got to, because obviously we've got COVID and the 6 rule and all that that's going to come in next, so that's going to give us a lot of work. Then I will just go to SLT and make a request for further staff. And the bottom line is, you know, if we have to have the staff to do it, then a decision is going to have to be made, because we have so much to do within that team. They have, I mentioned it the other night in services, they have worked their backsides off from the outset in March, you know, 7 days a week, whatever. And then on top of doing all of that, we have all of this to deal with. So it's just a matter of planning, prioritising, and making sure that the officers don't burn out.
Precisely. Thank you, Dave.
Councillor Geoffrey Kaufman.
Thank you. A couple of questions have come through my mind since Mr. Gill was giving his answers. Our taxi, that is Hackney carriage, that is registered with us, but does private car work in I think you said Folkestone or somewhere like
Kent,
that.
yes.
Yeah. Does that mean that because he's registered with us for a Hackney carriage, and it's an ordinary standard car, he can use bus lanes up and down the country because he's a taxi here? That's number one. And number two, does this legislation, will it avoid the problem that we had a year or two ago with us refusing a license to a taxi driver here, but a certain authority not too far away thought he was a great, wonderful person and could continue doing? Will that avoid that situation? Because we now are working together in a team. So our licensing officers enforcing for us could be city ones, if I understood it correctly. So how does it affect a situation like that?
Going to your first question, Councillor Kaufman, not all bus lanes are open to Hackney carriages and private hire vehicles. Some councils do allow it. If there is a Hackney carriage licensed by us and he's travelling, I don't know, Swindon or wherever, and there's a bus lane which is available for Hackney carriages to use, then yes, he can use it. the bottom line is that a hackney carriage is always a hackney carriage. Even when the driver is driving his family on holiday, if his vehicle is a hackney carriage, he can't let his wife drive the vehicle unless she's got a hackney carriage license as well. I mean, it's as simple as that. In terms of the other matter, and I'm trying to be somewhat circumspect, the whole idea of this guidance is that every authority will apply the same principles to applications. So arguably, if we refused an applicant today, then a neighbouring authority should refuse them next week or the week after or the month after, if they applied the guidance in the same way as we do. And when you read the guidance, it is fairly, it doesn't leave much room for nuances. You know, if I did include the link on the report to the guides, it is it's about 60 pages. But when you look at the previous convictions, for instance, it is quite clear. If somebody has committed this offence, you shall not grant a licence for this period of time. A bit like what we've got in our policy. So if the authorities apply it in the spirit that the guidance is there, then we shouldn't see this disparity between us and other authorities where we refuse and they grant, or they grant and we refuse. And that's the whole idea of the legislation.
Thank you, Chair.
Chair, just before you bring in Councillor Eaton, I believe Councillor Gattari is struggling to raise his hand virtually and he's indicating physically on the screen. So if you want to bring him in after Councillor Eaton.
I will do. So Councillor Robert Eaton.
Yes, thank you, Chair. If I've read it right, and we're giving permission to other boroughs to act on our behalf, if the driver goes to an appeal and the appeal is overturned, who would pick the cost up for this?
It would be us, because in essence, what we would be doing is we would be authorising those officers to act on our behalf. So the power that they are exercising is our power. So yes, we would end up, but before we would enter into any agreement with them, there is a standard agreement which has been issued by the LGA with regard to joint authorisations. So we would want to satisfy ourselves that the officers were competent and capable and understood what they were doing. We just wouldn't ask a grounds maintenance person to do it for us. It would be another licensing officer from another authority.
Does that answer your question, Councillor Eaton?
Yes, I think that covers it.
Thank you. Councillor Gattari.
Thank you, Chair. I just wanted to know about new drivers coming from abroad. As it's been told that they need to have a good certificate from the country they come from. And I would like to know which authority abroad will be authorising that latter.
As I previously mentioned, it depends very much on which country they're coming from and their governance structure. It may well be the local authority, but in all probability, it will be the local police authority. So I think in India and Pakistan, they have police commissioners as commissioners for police. It'll be that sort of area. It should come from the local district headquarters of the police force.
All right, fine. Thank you very much.
Thank you. I have no more hands raised. As I said at the beginning, this item is for noting only, and I'm sure that all councillors welcome the report. Before I close the meeting, can I, on behalf of this committee, thank all the licensing staff, not just the officers, but the backroom staff as well, for their hard work, especially during this period, and that if there is problems in the future completing this work, that they do let the committee know. So that's it for this meeting. Thank you and good